morning, everyone. Welcome back. Please take your seats so we can get started with our second panel. I just want to give a quick reminder to our virtual participants. Virtual attendees, please pay attention to the chat box on the Zoom. Your CLE and CPE codes will be put in the chat, and you must write them down in order to receive credit for this program. So with that, it is my pleasure to introduce our second educational panel of the day and our distinguished panelists, Amanda Steele, Melissa Root, Ann Vanderkamp, and Jennifer Lyday. This panel, Lyday like Friday, excuse me. Thank you, Jennifer. This panel will walk us through the life cycle of a mass torts bankruptcy case and dive into a few of the key issues from recent headline-making bankruptcy mass tort cases. So with that, I will turn it over to Amanda. Thank you.
Good morning, everybody. I'm Amanda Steele from Richards, Lake and Finger in Wilmington, Delaware, and I'll be the moderator today. Sorry. Is that better? Okay, I put myself back up. I'm joined by an esteemed group of women, and I'm really excited to present this panel to you. First, I'm joined by Melissa Root. Melissa is a partner at the Restructuring and Bankruptcy Group at Jenner & Block, where she serves as managing partner of the firm's Chicago office. Melissa has a deep experience representing creditors, official committees, debtors, and other stakeholders in complex financial restructuring matters and high-stakes bankruptcy litigation. She recently represented USA Gymnastics in its successful Chapter 11 case, which culminated in a plan of reorganization that was proposed jointly with the Survivors Committee and received unanimous support by the survivors. Melissa is a fellow of the American College of Bankruptcy Lawyers and was a member of the American Bankruptcy Institute's inaugural 40 Under 40 class. Next, we have Ann Vanderkamp. Ann is with Alex Partners in Chicago. She provides financial advisory, litigation support, and investigative services in bankruptcy-related litigation, including investigations involving allegations of fiduciary breaches and fraudulent transfers. Oh, sorry. Analysis of related party and other intercompany transactions, analysis of third-party asset transfers, and quantification of damages. Ann has provided expert reports and trial testimony in federal and state courts. And Ann is involved in mass tort cases, including narco and LTL. And lastly, we are joined by Jennifer Lyday, like it's Friday, that's what she told me. Jennifer is a partner at Waldrop Wall, Babcock & Bailey PLLC in Winston-Salem, North Carolina. Jennifer focuses on corporate Chapter 11 representations and related state court debtor-creditor representations. Jennifer has a deep experience representing secured creditors, distressed businesses, unsecured creditors committees, and trustees in business bankruptcy cases. She also represented buyers and sellers of assets in bankruptcy. Jennifer is currently on the panel of Chapter 5, Chapter 11 trustees for the Middle District of North Carolina, and she's a member of the American Bankruptcy Institute's 2021 40 Under 40 class. Jennifer's mass tort experience includes representing tort claimants in the Bestwall bankruptcy case, currently pending in the Western District of North Carolina, representing the state of North Carolina in the Purdue Pharma bankruptcy case, and representing the official committee of TAL claimants in the claimants 2 in the LTL bankruptcy case.
It doesn't exist anymore. Just for the record. But I put it in the.
Yeah. So what is our panel about? As we know, mass tort cases have been a large part of our news cycle in the past few years. Although Chapter 11 has been used in mass tort cases over the years, it seems in the last few years, a number of cases, for good or worse, which we will hit on, has expanded, and the types of cases has expanded. We can't cover every issue that arises in mass tort cases, but we hope to give you an overview of some of the issues that may arise. Melissa will start our discussion with the overview of the types of issues you see in mass tort cases. Then Ann will discuss how the recovery is funded and what does that look like, the types of structures of the trusts. And then Jennifer will discuss the hot button issue of third-party releases. We'll save some time for question and answers at the end, but if anybody has a question while we're talking, feel free to raise your hand and I'll try to jump in where we can. So I'll first turn it over to Melissa.
All right, thanks, Amanda. Can everyone hear me okay? All right, I'm so pleased to be with you all. And I just want to pause and stop by saying I was so moved by that last panel. I'm sure all of you were too. So thank you for that panel, and some sort of weird connection to mass tort cases. When I was in high school, there was a Boy Scouts Law Explorers program, and I had no idea what the field of law was like, but did that high school program. And to Judge Stong's point, there was a lawyer who's now a bankruptcy judge in that program that I would say is single-handedly responsible for me having an interest in this profession. So let's all go out and be that person to someone else. So as Amanda said, mass tort cases come up everywhere right now, right? We've got Purdue, Boy Scouts, Immerse, USA Gymnastics, LTL, Alex Jones, the list goes on. The past is really prologue, and this notion of using the bankruptcy code and the tools it provides to resolve a mass tort case is nothing new. And really modern day cases are all rooted in the Chapter 11 case of Johns Manville in 1982, which, for better or worse, depending on your perspective, really paved the way for litigation trust, channeling injunctions, and yes, third-party releases. So before we talk about today's problems, we thought we would time travel back to 1973, when the Fifth Circuit, in a case Borel versus Fiverr Board, holds that asbestos manufacturers are strictly liable to workers injured as a use of their product. And as a result of that, thousands upon thousands of lawsuits are filed with Johns Manville, which had been the primary producer of asbestos products, really at the center of all of this litigation. And in 1982, facing more than 10,000 lawsuits, with literally hundreds of lawsuits being filed every month, Johns Manville files for bankruptcy and takes advantage of the breathing spell that Chapter 11 provides. And like many of today's mass tort filings, Johns Manville didn't file for Chapter 11 because of a commercial financial event. This was strictly driven by the tort liability. Now, when we think about tort claims and tort liabilities, it differs importantly from commercial cases and really requires a different type of restructuring solution. So key among these differences, one, there's a causation issue, right? Like there are many different defendants that could have contributed to the tort, to the harm. There are also often major insurance issues. These are insurance issues in between the policyholder and its insurer, as well as insurer issues intra-insurers, where you have harms that span 20, 30, 40 years and multiple insurance policies and trying to find which claims slot in where. And there's also claims of additional insureds that aren't non-debtors, but may claim through that insurance policy. And so how do you resolve a situation where you have these non-debtors, you want the insurance money, but you have to come up with some sort of release? So ultimately in Johns Manville, a plan is confirmed that contains what was then really novel, but now pretty standard, features to address these unique issues of mass tort claims. And it provided for a litigation trust, which worked together with a channeling injunction to bar the filing of asbestos-related claims against the reorganized debtors. But it didn't stop there, because importantly, it was the debtors' insurers that contributed the vast amount of money to the trust. In 1982, $770 million went into this trust from the insurers, with 80 million of that coming from Travelers, which had been Johns Manville's primary insurer during this time. And so the insurers make these contributions because they want to be part of an insurance settlement order, which ultimately gets baked into the confirmation order, and which provides that upon the insurer's payment of the settlement funds into the trust, all persons, all litigation are restrained and enjoined from commencing litigation against those insurers relating to policy claims, which is really broadly defined to include all of the asbestos type litigation. So Congress responds to Johns Manville and to the wake of asbestos cases that get filed after Johns Manville. In 1994, it includes 524G, which there's a lot of discussion about now in terms of how we think about that expanding beyond the asbestos scenario. But 524G really codified the plan that sort of worked in Johns Manville. It permits courts to release third parties that could be held derivatively liable. It provides for a mechanism to approve these channeling injunctions and litigation trust if certain requirements are met. If you have 75% support of the class, et cetera, numerous other requirements. So staying with Johns Manville for a moment, because I think this is important when we think about today. The events that followed the 1986 confirmed plan didn't exactly confirm that these novel injunctions are totally okay and would be respected. Because about a decade or so after the plan is confirmed, Travelers, that insurer that had put in $70 million, starts to get sued directly under consumer protection laws, common law, on the basis that Travelers had conspired with other insurers, was aware of the asbestos issues. And Travelers is like, no, I have an injunction from a bankruptcy court. Like, this is not okay. And so everything goes back to the bankruptcy court. The bankruptcy court issues a TRO, mediation ensues, and Travelers kicks in an additional $400 million, right? 4 times, more than 4 times the amount that it had originally put in return for an order that clarified that, of course, the 1986 order always protected Travelers against this type of liability. So this gets appealed to the Second Circuit, which reverses on the basis that, like, this bankruptcy court completely mistook its jurisdiction, stepped way out of line here. It goes up to the Supreme Court. So third-party releases, will they go to the Supreme Court soon? Probably, but they've been there before. But when they went up, the Supreme Court reversed the Second Circuit and said that it wasn't resolving whether a bankruptcy court in 1986 or today being 2008 then, could enjoin claims against non-debtors that weren't derivative of the debtor's wrongdoing. But because the 1986 confirmation order had become final on direct review over 10 years ago, it's not going to touch this. And dissenting, Justice Stevens is like, wait a minute. Did you not notice that Travelers just paid $400 million for an order that said what the 1986 order did was effective and binding? Like, this means that there's an issue here, and it's a really lively dissent. And he tracks the language of 524 or 524G4. And in his mind, the types of claims that were being asserted against Travelers weren't claims where Travelers was directly or indirectly liable for the conduct and the claims of the debtors. So as we think about these issues now in 2022, you should all go read Justice Stevens' dissent. It's really interesting. So I suppose I could sum up by saying it was a mess in 1982 and it's still a mess in 2022, but I don't even have to do my part. No. But there's an important but, Jen. I'm an optimist. And I also am a believer that there's really no better mechanism to resolve these really messy, complicated mass tort cases than a bankruptcy court. And that's for both the victim and survivor constituencies and for the organization. And in my mind, that's because the bankruptcy courts are uniquely capable of stopping the music, bringing wide-ranging litigation to the court, and facilitating a settlement discussion and a process that provides for not just the current victims of the abuse or the disease, but also future victims, while at the same time allowing a debtor to reorganize. So as Amanda mentioned, I was part of the team that represented USA Gymnastics in its Chapter 11 case. Is Bernadette in the room right now? I saw her outside a minute ago. Bernadette. So I'm going to pause for an IWIRC story because Bernadette is the CFO of USA Gymnastics. And 3 years ago, when ABI was in person, USA Gymnastics needed a CFO. And it was at the IWIRC and the ABI event. Of course, Bernadette and I go way back, where I saw Bernadette and said, like, she's perfect for the role. And Bernadette has led the organization ever since in the CFO role. So, like, cheers for IWIRC and the connections that we make and the business that we develop for each other.
Types of mass torts?
Well, I think the first thing Congress should do is send whoever is thinking about this to an IWIRC meeting so that we can tell them how this really works, right? I mean, 524 is obviously a very reactive piece of legislation to a specific type of tort claim that in 1994 was overwhelming and all-consuming. But, you know, last year, the year prior, there were like 3, maybe 4 asbestos-related bankruptcy cases. And eventually, I mean, we may get to the time where there are no asbestos cases, where the latency period is such that we're just not seeing that. And does 524G become somewhat of a relic because there's no case that fits that? I think as Congress thinks about what it should do, maybe a less reactive approach and a more holistic approach to trying to come up with standards, with measures that, you know, recognize that we really need some creative features in the bankruptcy code to deal with mass tort cases. These releases, and Jen and I will go, you know, back and forth a little bit, but I think everyone can agree that in certain situations, For certain types of non-debtor parties, these releases are absolutely essential. Like, you cannot fund the trust if you don't have these releases. At some point, and everyone is different where they are on the line, these releases become really problematic. So I think there's no bright line test that could be in there, but maybe some factors. And I do think 524G is helpful in terms of at least looking at the framework that we should consider. And important among that framework, the elevated level of class support, the 75% level that's needed to approve a plan in a circumstance like this. So we'll see. I'm sure they'll mess it up.
Thank you.
Well, Melissa, thank you so much for that great history lesson on Johns Manville, and then also the great overview of the USA Gymnastics case, both very interesting. But as Melissa said, the bankruptcy court can provide a great structure to the recovery process for victims in mass tort cases. In these situations, the debtor's plan of reorganization usually creates a trust funded by the debtor's estate. Once the plan of reorganization is confirmed, the court issues, as Melissa mentioned, a channeling injunction that releases the debtor and specified third parties from liability, and then channels the injured party's claims to the trust for payment. The trust then distributes the proceeds to the victims pursuant to the established trust distribution procedures. Jennifer is going to get into more detail regarding the current issues
Excruciating.
surrounding the releases. But what I wanted to talk about in a bit of detail was the different types of trusts. You've got your evergreen and how they can be funded. You've got your evergreen trusts where money is continuously flowing in. And then you've got your fixed contribution trusts where a set amount is put into the trust. And you can also have situations where the trust is funded via a combination of the two. But regarding evergreen trusts, an ideal situation for your claimants would be the establishment of a trust where the claimants are guaranteed to be paid in full on the value of their claim, because the parties are required to make ongoing payments into the trust in the amount of those claims until the point where there are no longer any claims. Examples of evergreen trusts would include the NARCO Asbestos Trust. NARCO was a manufacturer and distributor of refractory products that contained asbestos. In 2002, NARCO filed for bankruptcy protection under the weight of those claims, and NARCO then emerged in 2008. But NARCO's predecessor in interest at the time these products were sold was Honeywell. And per the trust agreement established in the NARCO bankruptcy, Honeywell was and is still obligated to fund the trust up until the point in time that all of the asbestos-related claims against NARCO are paid in full. Evergreen trusts can also be funded through public benefit corporations. So in certain situations, a debtor can agree to convert its tainted business into a public benefit corporation after bankruptcy and then contribute its future profits to the victim's trust. Purdue Pharma is an example. So under the current plan of reorganization for Purdue, Purdue Pharma will cease to exist. But Purdue will emerge as a new company referred to as NOAA Pharma, which will be owned by the National Opioid Abatement Trust, which will be an entity controlled by the creditors of Purdue. This new company will be run for the purpose of funding the Master Distribution Trust established as part of Purdue's plan. The Master Distribution Trust will then disperse trust proceeds to a series of other trusts. It's a very complicated structure to compensate certain victims or establish programs to benefit the public in an attempt to abate the opioid crisis. In addition to distributions from the new company, the Master Disbursement Trust, sorry, it's a little bit of a tongue twister, will receive proceeds from insurance settlements, as well as a $6 billion contribution from the Sackler family in exchange for releases of their liabilities. One of the central issues leading up to this settlement contribution from the Sacklers were fraudulent transfer allegations. For many, many years leading up to Purdue's bankruptcy, the Sacklers paid themselves billions of dollars in dividends and distributed Purdue profits to other offshore entities. The distributions that fall within the appropriate look-back period under Section 548 could be considered fraudulent transfers and could be subject to recovery by by the estate. It's of note that through the plan negotiation process, this contribution from the Sacklers has increased dramatically. So if you have a situation where there aren't, operations of the debtor or other liable parties to continuously fund the trust, then you're left to look at kind of fixed settlement contributions from other parties. And as Melissa mentioned, a huge component of this is, your insurers and negotiating settlements with them and getting those settlement proceeds then into the trust. Another means to fund a trust could be through the liquidation, actually, of the debtor. And Insys Therapeutics, another opioid manufacturer, is an example of this type of situation where the company actually liquidated, wound down, and then put that fixed set of proceeds into the trust. And as Melissa mentioned, USA Gymnastics would be another example, and Boy Scouts is another example of a case where trusts established for the victims are funded with fixed contributions. The challenge with this sort of funding, though, can be, if the number of claims and the value of claims is not established and known at the time that these settlements are made, you could wind up with a situation where future claimants could come on board, and then adjustments might have to be made to the distributions over time as there is less in the pool of funds available.
Thanks, Anne. Have you seen any unique funding sources in these cases?
Yeah, I'd say one of the more unique current ones, I think, is the LTL case. And I think that's unique, namely for how LTL got into bankruptcy in the first place, which, as I'm sure you're all aware, Johnson & Johnson had a consumer products division that manufactured and sold Johnson's baby powder and another product called Shower to Shower. And allegations started to arise that these products were causing either ovarian cancer or mesothelioma. And Johnson & Johnson has seen, a huge increase in the number of claims being filed against it with regard to these allegations. And so under the weight of these, growing claims and some really massive judgments that have been issued of late, Johnson & Johnson decided to engage in what is known as the Texas two-step divisional merger, where they took that consumer products division and put all of the business operations and assets into an entity that they're calling New JJCI, and they put all of the tort liabilities in an entity that they called LTL. And then LTL immediately files for bankruptcy upon creation. The current plan of reorganization for LTL calls for the trust to be funded by New JJCI and Johnson & Johnson. They're both jointly and severally liable to fund the trust indefinitely up into the value of New JJCI. So I think, it's definitely a very interesting case, and it's currently ongoing. And I think, we'll see what happens with it as to whether or not, it is allowed to proceed.
Yeah, we joked that we didn't really want to touch too much into the Texas two-step because that's probably its own panel altogether. So we were
at ABI, right?
Yeah, and
So
yes.
look forward to the Texas two-step panel at ABI spring meeting.
Yeah, so we were trying to stay high level with that one, but thank you. And I guess that'll lead nicely into the releases, because that's why we do this, why everybody wants to do all these trust structures.
Yes, that's right. And it's funny that there's very little foundation in the bankruptcy code for these types of releases. So I think you've heard from
That's
Melissa.
a debatable point.
It's debatable. So you've heard from Melissa, you've heard from the other panelists about, the fact that these third-party releases are really at the heart of why these mass tort bankruptcies exist. And kind of the two purposes, I think you heard Melissa speak to both of them. is that, first of all, they are essential to the compromises that can be put into the plan, because the various different funding sources are not going to give the funds for the settlement if they are not going to get the piece. So that's why it's really necessary there. And also it stops the litigation from going forward that could really impede the reorganized debtor. So that's kind of the why. But I wanted to dig in a little bit into the, just the legality of these types of third-party releases, because, over really since December of 2021 and all the way to the present, and then probably for the next couple of years, that legality is going to be litigated. And I want to make sure that we all have a really good foundation for what we're really fighting about. So I start my "Are they legal?" section of my notes with, as of right now, this very minute, until the Supreme Court considers the issue, which it very well may do because of the Purdue Pharma case, depending on what the Second Circuit does, the majority of circuits do allow non-consensual third-party releases as part of a Chapter 11 plan under some circumstances. So some do, the majority, and then some do not, the minority. And I wanted to kind of understand, well, what is the argument? What are they really at base arguing about? And it really comes down to Section 524E of the Bankruptcy Code, and whether or not you interpret that section broadly or narrowly. Now, until I did a lot of this research, I couldn't have told you what 524E says. So I'm going to tell you. That is essentially the section that talks about what a discharge does. So Section 24E provides that the discharge of a debt of the debtor does not affect the liability of any other entity on, or the property of any other entity for such debt. So, okay, that's what the actual provision says. So the majority of circuits that allow third-party releases, they look at that section and they say, well, that section merely explains the effect of the debtor's discharge and was only intended to ensure that a debtor's discharge does not automatically release any third party's liability for discharged debt. But it in no way prohibits a bankruptcy judge from issuing an injunction, a third-party release, if it is necessary, if it benefits the plan reorganization process. Okay, so the other circuits, the minority of circuits, they read it broadly and they say, look, okay, they see it broadly as prohibiting a plan from granting a release or injunction to any party other than the debtor. And so those circuits can then not rely on Section 105A to create the injunction, because we all know that Section 105A does not create substantive rights and cannot in any way cannot allow courts to issue something that's inconsistent with the bankruptcy code. So if you read 524E broadly as prohibiting third-party releases, then you can't use Section 105A to be inconsistent with that provision. So currently, and traditionally, it's been seen that the Fifth Circuit and the 10th Circuit and the 9th Circuit, depending on what day of the week it is, have said we follow this minority approach, saying that third-party releases in general are just prohibited and bankruptcy courts can't enter them. The other circuits, to various degrees of certainty have allowed them. I'll get back to the Second Circuit, the Third Circuit, the Fourth Circuit, the Sixth Circuit, the Seventh Circuit, and the 11th Circuit have, traditionally been thought to follow the majority approach. The First Circuit, the Eighth Circuit, and the DC Circuit, they've not really directly addressed the issue, but they've got some opinions that have made the people that think about these things think that they are generally allowed. And then again, the 5th, 9th, and 10th are the ones that follow the minority approach. Until very recently, the Second Circuit was seen to be kind of fairly squarely in the majority approach of allowing third-party releases. But then Judge McMahon's decision in December of 2021 in the Purdue Pharma case basically second-guessed that general traditional belief, because she said that, in that opinion, although the Second Circuit identified the question as open back in 2005, it has not yet had occasion to analyze the issue. Its only guidance to the lower courts uttered in that 2005 opinion is this: because statutory authority is questionable and such releases can be abused, they should be granted sparingly and only in unique cases. Well, for Judge McMahon, that was not enough. that guidance from the Second Circuit was not enough for her to basically find statutory authority for third-party releases, because that was really the issue that she found. Is it kind of looks like Section 524E could be broadly construed. But I think her real problem was that there was not a section that anybody could point to in the bankruptcy code that says this is allowed. And folks point to different things when they try to find that statutory authority. The only one that I found more compelling than the others was 1123B6, which I think is the provision that says, and I had it in my notes somewhere, but it talks about what a plan may include, and it may include essentially anything else that is allowed. And so that's what people are focused on. They're like, well, if it's not prohibited by the rest of the bankruptcy code, then a plan may include it. Now, of course, if you're in the 5th or the 10th Circuit, maybe the 9th, you say it is prohibited because of the broad reading of Section 524E. But everywhere else that doesn't review it or doesn't interpret 524E that way, it doesn't prohibit it. But what Judge McMahon really focuses on is the existence of 524G that Melissa was talking about. Look, Congress provided specifically for third-party releases in a specific context, the asbestos context. And if Congress had interpreted, had wanted the bankruptcy code to allow this third-party releases in other areas, it could do that. It's been many, many years, 1986, right?
94,
Since, 94, since it was implemented, and no one has ever moved to expand it. And she really focused too on the legislative history of Section 524G. And there was a specific, I think, Judicial Committee note that said, hey, we're really doing this because we recognize that in this kind of unique scenario of asbestos litigation, this is vital to it's just a really good idea, and we like this. And we're going to use this example, or use this as an example so that we can determine later on if it should be expanded to other areas. And so Judge McMahon was basically saying, look, we can't look to their silence or the science of the bankruptcy code as support for third-party releases. In her mind, silence was not acquiescence. And so that's why, you know, she says, no, there's no statutory authority for these third-party releases. And it's now going to be decided in the Second Circuit. So she basically said, you didn't do it before, you punted it. I'm not going to allow you to punt it again. You're going to decide this issue. And those oral arguments, I think, are this Friday, April 29th at 10 o'clock. So I definitely want to, so everybody pay attention to what comes out of the Second Circuit this week. It's going to be huge. And, you know, I can't imagine that the Supreme Court is going to be able to punt it this time, because I mean, I'm glad Melissa brought out the fact that this issue has not been decided intentionally since at least 2008, and really before that. So I think it's really important that this get decided. So I did want to just touch on as well. So what is the test? Well, it's different in every court, in front of every judge, in front of every circuit. So, okay, we'll just put that out there. Go check your own place, go check your own circuit, go check your own cases. But there is kind of the master mortgage decision, which a lot of courts look to when they are deciding these issues. And in fact, the Chapter 11, I think the ABI committee that came out with all of their recommendations about the Chapter 11 world actually, I think, adopted that test as what should be used in third-party releases. And I think it was very much what USA Gymnastics satisfied. And it's a 5-factor test. And the 5-factor test really focuses on, I think, in an effort to find the unique and rare situations where third-party releases make sense. Because when you read a lot of cases in this area, you focus on and hear that these situations should be rare. It should be extraordinary circumstances, unique circumstances. They shouldn't be in every case. And so I think the backlash that we're getting now about third-party releases from first Judge McMahon and then Judge Novak in the Eastern District of Virginia is that disconnect between these are supposed to be rare, and yet we see them all the time, especially in certain courts and certain circuits. And there's a real disconnect. But that 5-party test that the ABI Commission endorsed, it basically includes an identity of interest that must exist between the debtor and the third party, usually an indemnity relationship. So think the insurers. That's exactly that situation. And the third party has contributed substantial assets to the reorganization. So you've got to pay to play. If you're not paying to play, you should not get a third party release. End of story. The release is essential to the reorganization, and without it, there is no likely or little likelihood of success. And then to Melissa's point, a substantial majority of the creditors agreed to the release, specifically the impacted class of creditors, which have overwhelmingly voted to accept the proposed plan treatment. And then the plan provides a mechanism to pay for all or substantially all of the claims of the class. So these 5 elements, they're not really elements that must be satisfied even in the courts that follow it. It is more like a 5-factor test. You kind of look at each factor and say, does that weigh in favor of enforcing the release or against enforcing the release? I think my personal belief would be that you do need to satisfy all 5 of these tests, and that you need to be doing so clearly. I might put a clear and convincing standard on this one. And so those are kind of the things we're looking at when we're thinking, okay, is a third-party relief appropriate in the circumstances? Okay, so I just want to I want to end briefly with some of the really kind of hot button, cases that are really determining this issue right now. So I've mentioned Purdue Pharma. We're all going to be watching what the Second Circuit does on April 29th. And then I just briefly mentioned Judge Novak's decision in the Eastern District of Virginia. So that's in the Ascena Retail Group case. So I think this bankruptcy court order is very much like, okay, abuse. So abuse of the third party release idea. Because the bankruptcy judge there, and this was the criticism of Judge Novak, did not actually apply the test that is very much in the Fourth Circuit. So there's a version of the 5-part test that was adopted in the Fourth Circuit that looks very seriously at all of these issues. And basically Judge Novak said, you didn't really even apply that. And it's now become very normal in the Eastern District of Virginia, especially in the Richmond division, to have these types of releases. And he basically said, that's an abuse of these third-party releases. But he did more. He didn't have to. He did more though. He said that wasn't an appropriate use of it, didn't mask the test. But he goes further and says, and the bankruptcy court doesn't even have the jurisdictional authority to approve these third-party releases, which is funny because Judge McMahon in Purdue Pharma said, yeah, we do have jurisdictional authority to do this, but there's no statutory authority. So therefore, no. But Judge Novak said there's no jurisdictional authority. And he harkened back to Stern v. Marshall and said, I remember Stern v. Marshall? That used to be the hot thing, right? So I bet we get this new Supreme Court case, we're going to hear once again a lot about Stern because they're going to have to decide both the statutory question as well as the jurisdictional question. So, it's a hot mess, despite the fact that the majority of circuits currently allow it. They are now really being questioned. Now, I'll say there's that negative. There was also the recent positive decision in favor of the third-party releases in Mallinckrodt, which is a Delaware bankruptcy case. And Judge Dorsey, we were discussing this a few minutes ago. He was basically like, I hear you, Judge McMahon. I hear you, Judge Novak. I'm in the Third Circuit. And here in the Third Circuit, under the appropriate circumstances, and this was the appropriate circumstances, I'm going to allow it. I will kind of differentiate Mallinckrodt from the Ascena retail case. It did seem, and Judge Dorsey took great pains to show that in Mallinckrodt, they really met the standard. There was a lot of evidence as to all of the elements of the test. There was, it was very, it was very clear in that case, there was only one objecting creditor other than the U.S. trustee, the state of Rhode Island. The state of Rhode Island objected to it. Everybody else was in favor. So they definitely passed the overwhelming creditor support test. And I think also there was a substantial contribution, over $100 million from third parties who are getting the release. So, so in that situation, the judge, I think, felt comfortable doing it, but recognize there's some doubt that I have statutory authority and constitutional authority, but it's not to me to change Third Circuit law. So that is out there. That was in February of this year. And we all need to be watching Boy Scouts as well. So I think about 2 weeks ago, maybe, they finished their month-long trial of confirming, in an effort to confirm the Boy Scouts plan. And, the judge there made clear that they're going to try to get this out as soon as they can. But the articles that I read about it said that the judge specifically questioned, debtor's attorney about why the release here was necessary. And, there were about 100, the different sources I looked at said between 100 and 140,000 different partner organizations were going to be receiving a release under this plan. And so that was, I think, probably troubling to the judge. Maybe troubling is a strong word, but she knew she had to consider this and to, especially in the current environment, make a very strong showing for whatever way she comes down. But I liked the quote that the debtor's attorney, is she here, Jessica? She's got busy. She's pretty busy right now. She basically said, it's not as if we're requesting releases to tens of thousands of Sackler families. These are churches and other nonprofits sponsoring these Boy Scout troops. So, I mean, it does seem a little bit different.
I do think that it's a very context-driven analysis, which makes it a tricky one to think about a legislative solution for. And I think that's the problem, is that you have 524G, which maybe worked and maybe should be expanded, but like where is the line? And I think, you know, that the GN Marine case, I think that third-party releases aren't participation trophies. You don't get them for showing up, right? Like,
pay to play.
Okay, we're all there. It's not there, but like what amount of showing up? And I do think like the fact that the Johns Manville, when that went up to the Supreme Court, the Travelers case, that was in 2008. That was before we were thinking about constitutional authority and consent and all of that, which also, you know, works its way into these releases in addition to whether there is, and there is in 1123, a statutory hook to approve these releases. But it's just so, I think, context driven, and you can distinguish one case from the next from the next.
That's right. And it's very hard to not see some of the opinions as results oriented because of the context. And I totally agree that that's what makes the congressional fix a very scary one, because depending on the circumstances, we all have, I think, a different sense of, there's a sense of fairness. I mean, I think the overarching idea with the third party releases, and actually Judge Dorsey in the Mallinckrodt decision, am I right? Judge Dorsey, yeah, no. The judge, I get on my judges.
Dorsey.
Okay, right, I'm right. Judge Dorsey in the Mallinckrodt decision basically was like, okay, the overarching thing is these must be necessary and fair. They must be necessary and fair. And so that's what the 5-part test gets to. And I think whenever you are walking the edge of what is necessary and what is fair, that's where you're going to get the real criticism. And I won't talk too much about the Texas two-step, but I think the criticism there is that it feels less necessary. It feels less fair. Because in the context of a melting ice cube, a John Manville situation where there is no way that there is going to be a company able to pay all of these claims, and that company itself accepts the burdens and the benefits of bankruptcy, I think we can all agree that we'd rather just spread the wealth to as broad a number of folks as possible. But where this has gotten to today is it seems like in some situations, the necessity is not there, and then the fairness may not be there. And so the farther that you get from not satisfying the 5-part test, I think that's really the danger. And so I'm certainly not one to say that I think that third-party releases in the right circumstances should be allowed, whether through a congressional fix. I'd much rather the Supreme Court find statutory authority and congressional and jurisdictional authority, but set a very clear test in a Supreme Court decision that tells us exactly where the lines are. Because otherwise it's just, I mean, Judge McMahon makes the point that when every case is unique, no case is unique, right? Okay. And so that's what she's fighting against. And I think what Judge Novak is fighting against. Like, there very well may be a use for this, like in U.S. state gymnastics, like in the Dalcon Shield case in the 4th Circuit that was decided many, many years ago. But every case cannot be that case. And so we need to kind of be mindful of that. And I think that's what the jurists are now asking for, is more clarity.
And I think an interesting question to consider is then in a world where these releases, may no longer be allowed, then what? Like, what is the implication of that?
Well, it's not good for our business.
But it's also, I mean, I
It's
just
gonna
think
drive up the contributions
not good for
to get consensus.
plaintiffs too. I mean, there are winners and losers in litigation in all different, like as believers in this process, we have to think that we're doing some good when we reorganize a company, no matter the circumstance. And I do think, the provision for future claimants in equity and the accessibility of, instead of going through a lengthy lawsuit, you're submitting a proof of claim form. There's real efficiency drivers that I think also support it. I know we're out of time. So.
I think we are. And I just want to thank you all. I've learned a lot through this process, and there's so many different cases that I think makes the area of law very unique. And it's definitely an area of law where we practice, where every day is different and a new, if bankruptcy practitioners are generalists, I think mass tort makes you extreme generalists because you learn a lot of different things. So thank you guys all for being on the panel, and thank you all for listening to us.